You remember to throw up. The young people didn't pick up on
Okay, you guys all set?
Yes.
Good afternoon and welcome to the Senate Judiciary Committee's meeting of, my goodness, what is it, March 8th, 2022. We're going to start the day by opening the public hearing on House Bill 597 and recognize the prime sponsor, Representative Erf. Good afternoon, Representative.
Good afternoon. Thank you, Madam Chair, members of the committee. For the record, I'm Keith Erf, representative from Ware and sponsor of HB 597. HB 597 protects an individual's informational privacy from government intrusion. It bars state and local governments from accessing an individual's personal information, which he or she provided in confidence to non-governmental third parties. In 2018, New Hampshire citizens passed the Right to Privacy Amendment to our state constitution, with 81% voting in favor. This says an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. HB 597 starts the process of defining this right in statute. It defines what constitutes personal information as it applies in the bill. It states the expectation of privacy that we have as it relates to our personal information that we give to companies we interact with in our daily lives. It provides that no government employee, elected official, or government contractor shall acquire, collect, retain, or use this personal information. HB 597 includes clear exceptions for state agencies collecting information as part of their function, exceptions for warrants and emergency services, exceptions for information collection required by state or federal law. The initiative that the individual agrees need not be subject to this privacy. The bill clearly states this chapter shall not be construed to create a cause of action against a corporation or its officers, employees, or agents for providing information to a municipal, state, or federal department, agency, employee, or contractor in accordance with the provisions of this chapter. We have seen over the past 2 years that our constituents are concerned with the privacy of their information in a variety of domains. The House passed both this bill and HB 1662 on voice votes this year. HB 1662 creates a data privacy board to oversee the Department of Health and Human Services use of data. Earlier in the year, this body passed SB 302 by voice vote, establishing the Personal Privacy Protection Act. The House Judiciary Committee retained HB 597 from last year. I believe they did a good job balancing the interests of the state with the privacy rights of the individual. A large body of our personal information stored in the ether and of the potential damage that can be done by those with access to this information. A consultant to the healthcare industry told me she recently received patient data from a hospital client that contained personally identifiable patient information. Surely this wasn't intentional, but is indicative of the way personal information can be mishandled. The bill does make trade-offs. Warrants are required to obtain personal bank records or phone company location tracking records, for example. Previous Supreme Court decisions allow access to such third-party records without a warrant. Recent changes to law, such as our New Hampshire constitutional right to privacy, paint these decisions in a different light. The overwhelming support that our constitutional right to privacy received indicates to me that many believe this information is private and shouldn't be readily obtained by the state without a defined need. As the Honorable Sandra Keynes wrote for the Judiciary Committee when an earlier version of this bill passed the House in 2020 and the constraints of COVID prevented it being considered in the Senate. Quote, "The citizens voted overwhelmingly for a constitutional amendment to protect their privacy. This bill is a modest attempt to put some statutes in place to start the process. It does not cover everything, and future legislatures will certainly find more areas to cover. It does require warrants for governmental bodies before they snoop. However, it does allow for an emergency situation. Your personal information should remain private to the extent possible." End quote. I believe it is time to follow through on the privacy concerns of our constituents by clarifying what the state of New Hampshire and its political subdivisions can do with information being collected from third parties without impacting the statutory duties of government. Thank you, Madam Chair, members of the committee.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Senator Gannon?
I probably should be holding my tongue because I'm not as knowledgeable as I should be on this, but you can help me get there. So you said no cause of action earlier against a business, right, under this bill? That this was only to be against the government?
Correct.
So that hospital that let out the personal information that you mentioned, was that a private hospital? And so there'd be no cause of action against them? You mentioned a hospital that released someone's information. So this bill wouldn't apply to them either, correct?
I would imagine that would be the case. That actually was, that did not happen here in New Hampshire, but.
Oh, okay. Okay, no, I'm good for now. I'm just going to listen. Thank you.
Okay.
Are there any further questions? Okay, seeing none, thank you very much, Representative.
Thank you.
The chair will call Representative Representative Kurt Walper.
Thank you, Madam Chair, members of the committee. For the record, my name is Representative. Okay, so thank you. For the record, my name is Representative Kurt Walper. I represent Stratford District 3, the towns of Stratford and New Durham. I sit on the Judiciary Committee in the House. And it was our pleasure to work on this bill. When it came to us, it was very different than what it is right now, which is why we retained it. We worked with the sponsors. The sponsors worked very hard over the summer, and we have focused this bill solely on government. So in response to Senator Gannon's question of private hospital, the exemption in this is if there won't be any action for them if they're in compliance with, in responding. If they respond according to what this bill says the government can do, there's no action against them, right? But it's not intended at this time to talk to private enterprise because we felt that it was a government issue. Government should be is the most restrained. That's where we have the biggest risk of losing our privacy rights, and they represent all of us. The definitions are broad, which is a good thing. So they're intended to cover pretty much any way that any provider of information services or any information that would be subject to this definition of personal information, which is also quite broad. It's intended to provide the fullest protection that we can under the law. So, and I would just say that it received a strong bipartisan vote in committee, 18-3, and it passed the House very easily, as it had with a lesser previous version. And with that,
Okay.
I'll be done.
Thank you very much for your testimony, Representative. Are there any questions for Representative Walper?
Just me. Everyone else must
Senator
understand everything, but I don't. So, Kurt, on page 2, you're talking any person violating. Is that a willful violation, or is it if they unintentionally? And I'll just do my follow-up now. I think it's lines 17 and 18. Any person violating. Would it have to be a willful, or is it just an erroneous? And would that be if they released 1,000 pieces?
So you're talking, so I don't have line numbers on what I picked up.
Okay,
at
any
that
person-
So it's any person violating
The provision. Why not you, so if
guilty of a
an innocent
violation of a
mistake?
natural person or a misdemeanor if any other person?
Yeah, so if I make an innocent mistake, is there a difference between a willful mistake where I knew what I was doing, or if they unintentionally do it and it releases to thousands of people, is that going to be a $1,000 fine for every person who received the information? Or is it just the one act when I released information? So it's a two-part question.
Well, that's about a three-part question, but that's okay. So first of all, yes, there's a difference
Willful.
between a natural person and any other person.
No, I'm not looking there.
Right.
Is it willful? Is willful?
Willful is there for a reason.
Well, I don't see willful. I
Well,
wondered
you
if it
said
should be there.
willful. I didn't.
No, my question was, it doesn't say willful, so it's just
Oh.
says any violation. So I poorly phrased my question, I'm sorry, let me try again. So if they willfully violated versus an unintentional, you don't have any differentiation in the bill, should there be?
That's correct. I don't think so.
Okay,
The intent is to protect your information. Right? And
okay.
so there you go.
And then my follow-up would be $1,000 per incidence of violating this. So if I release someone's information to the same information, but I let it out to a lot of people, is it every single time is going to be $1,000?
I can't
Or is
answer
it
that.
just the one incident?
I'm not enough of a lawyer to answer that question.
Okay, thank you.
Are there any further questions? Senator Khan?
Hey, thank you, Madam Chair. Representative, nice to see you again. And whether this is for you or Mr. Lehman, but same two sections that were previously addressed, I don't understand Section 4, and it's probably just not understanding the difference between a natural person and any other person.
Well, a natural person has flesh and blood and other people don't.
I'm sorry?
I said a natural person has flesh and blood. Other persons, as considered by the law, do not. So the municipality does not have flesh and blood, but it's a person.
Okay.
Senator Whitley?
Thank you, Madam Chair. Thank you, Representative. Do you agree that maybe, as an example of a non-natural person would be like a corporation? Or that a separate,
This bill deals strictly with government.
okay.
The government, you know,
Just
you
a
can
big
define the government as a corporation, and it is called that in many places.
Okay. So I'm just sort of trying to think about, thinking through Senator Khan's question about natural person versus what would be included in the category of persons.
Any state agency, probably, well, I don't know how far I want to go with that. Again, I'm not a lawyer, we don't parse those things that far.
Okay, are there any further questions? Okay, seeing none, thank you very much, Representative.
Thank you.
The chair will call Ben, is it Ayudi? Agati, I wasn't sure if that was a Y or a G.
Good afternoon, Madam Chairwoman and ladies and gentlemen of the committee. My name is Ben Agati. I'm a Senior Assistant Attorney General. I currently serve as the Chief of the Homicide Unit for the New Hampshire Department of Justice. The Department of Justice is not here to take a position on this particular bill, but we do have a couple of observations with regards to our observations of the portions of the bill and what some of the language would mean if enacted, and specifically for myself with the expertise of what would happen in a criminal setting. In essence, basic investigations here often work for us to exclude individuals as much as include individuals. And the primary thing that the Department of Justice sees with the language, if this committee chooses to go forward with the language as is that it will cut into the grand jury's ability to do an investigation. A grand jury, their purpose is to discover whether probable cause exists to believe that a crime has been committed or has not been committed. The legislation as proposed talks about not allowing the grand jury to do that, but you would need to get a probable cause search warrant. Probable cause is a different standard. That has to be probable cause that the evidence that you are seeking is in fact evidence of a crime. A grand jury would be left without the ability under this statute, as written, would be left without the ability to go and get a number of different records that they commonly do to exonerate or incriminate an individual. And again, I think one of the common misperceptions about prosecutors is we say no a lot more than we say yes. And in that, it's frequently in doing investigative work that exonerates an individual or corroborates an alibi that the grand jury would not be able to do under the statute as written. Mainly because of that difference of going to a probable cause standard for a warrant as opposed to the grand jury standard, which is reasonable suspicion that it could be used to determine if probable cause exists. That's the primary point that the Department of Justice wanted to point out to the committee. I'm happy to take questions at any time.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator Khan.
Thank you, Madam Chair. Thank you, Mr. Gotti.
Yes, sir.
What section would you reference in particular to your concern?
When we're referencing with regards to section Roman numeral 3, when we talk about where areas of paragraph 2 would not apply, there is not an exception within that area for the work of the grand jury. And grand jury subpoenas and basic investigative work that is sometimes done to get, again, information that usually exonerates people rather than incriminates them, that occurs at the grand jury level or part of basic investigations. That's where we don't see that there's an exception there, or where there is an exception necessarily where the business and the individual have come to an agreement ahead of time, and that may be contained within their terms of agreement to use that service. Part of the language of Roman numeral 2 speaks with regards to, when we talk about the definition of third-party providers of information and services, it then says, including but not limited to, and then there's a list of different services that are there: cellular, landline, telephone, electric, water, utility, and the list goes on. With that language of including but not limited to, that would include every single business that collects any of the identified personal information. So, for example, I can see in Roman numeral 1, we talk about an individual's address, cellular telephone number, such basic things like that as written. That could include a hairdresser if you call to make an appointment. That could include a restaurant if you leave a phone number for the restaurant to call you back. That would be considered personal information as it's written by the statute. Again, just to give you an example of how that applies, but where the grand jury's work comes in is we're often looking at records like that, or the grand jury, I should say, is requesting those records to be provided.
Madam Chair, follow?
Yes, follow up.
And so elsewhere, it then says, but you can obtain a warrant for that information. Are you saying that at that point in the investigation, that's not feasible? Or?
It may be that to obtain a warrant, the judge has to find that probable cause exists, that a crime has been committed, and that whatever evidence that you're seeking, whether it's cell phone records or whether somebody had a restaurant reservation, that material is evidence of a crime. A grand jury is determining whether a crime has occurred. And so they're looking at a reasonable suspicion standard to be able to learn if this information will tell them that a crime has or hasn't occurred. A judge's standard is that they have to believe that this is evidence of a crime. So it's that early investigative step that gets cut out without an exception.
Specifically, the reasonableness of of suspicion.
Essentially, yes. The language that's been used in previous court cases in the New Hampshire Supreme Court, again, and I'm just sticking with that language, is that the grand jury's purpose from common law on forward is to discover whether probable cause exists to believe that a crime has been committed. Using that definition that the court has given us, that's just different from probable cause, that this evidence is evidence of a crime.
Thank you. I appreciate your being here. I've followed some of your work, and it looks to be really exceptional.
Thank you, sir. I appreciate it.
Good to see you.
Senator French?
Thanks, Madam Chair. Thank you for coming. Could you look at line 21 and tell me where a grand jury would fall into those definitions?
With regards to that, Your Honor, Sir, there's not a listed that says the grand jury shall acquire or collect. However, every grand jury appoints an agent in order to be able to take those records in. And that agent is frequently the law enforcement officer, whoever the chief investigator is. In addition, you're talking about, it says that nobody here can go ahead and, just want to make sure I'm getting my terms correct, acquire, collect, or retain. Everybody in the process of getting that grand jury subpoena out would meet as a municipal, county, state employee.
They would?
Yeah.
Okay, great, thanks.
You're welcome.
Okay. Are there any other questions? Okay, seeing none, thank you very much for your testimony.
Thank you for your time.
The chair will call Tom Mullins.
Hi, good afternoon, members of the committee. Madam Chair, my name's Tom Mullins. I'm the city attorney over in Keene. And quite frankly, we have some concerns about the bill as drafted. In our experience, whenever you drop one of these into a real-world context, it can be really difficult to anticipate how it's going to apply and how it's going to affect the operations of the city and the individuals who help us run the city. You know, just a couple of concerns that jump right out under lines 13, 14, 15, where we define third-party providers of information services. We provide water and sewer services. That's sort of separate from our general fund. We're a water service provider. And, I have a concern that, quite frankly, we have individuals, unfortunately, that aren't able to pay their water bills, and we have to collect personal information from those individuals and corporate entities in order to be able to follow up and collect that bill. So it's a little unclear to me how that would apply in our specific context. I'm also a little concerned about the internet service providers. We do have an internet service provider that we have to work with occasionally. I hate to admit it, but sometimes we have employees who may not use their internet services in probably the most appropriate manner. We try and be very careful about that, but the reality is that that exists, and we need to work with our internet service provider for that purpose. That also arises in the context of a claim for some sort of copyright protection that may apply. This happens occasionally when we have individuals in the library who, despite our request to use our services and our Wi-Fi in an appropriate manner and a lawful manner and not copyrighted information, that happens. And we need to be able to follow up on those. Otherwise, we risk the loss of our internet service altogether throughout the city. So that's an important consideration for us. With respect to the paragraph 3, line 26, I note that state regulatory administrative agencies and such are given an exemption from paragraph number 2. If you are inclined to adopt this bill, I would suggest that you do at least add municipal entities. We do have regulatory functions, and we do have to collect information personally from, that would fall under the definition of personal information to fulfill those functions. It doesn't seem to be appropriate to allow the state, but not to allow the municipalities to do that. With respect to the discussion that happened on the enforcement question, and that starts basically lines 16, 17, 18, and so on. I share the comment that was raised about willful or intentional conduct. There is no reference to that in there. The reality is that we have individuals who have to navigate through all of this. These people almost always work in good faith. There was a comment made that, well, I'm not a lawyer and I don't really know how all of this will apply. Well, the reality is most of our public employees are not lawyers either, and we require them to navigate through this. If you are inclined to adopt this piece of legislation, there should be some safe harbor for and include willful or intentional action with respect to the individual. Because I noticed, note that this applies against that individual personally. We're seeing more and more of this, quite frankly, where we reach around the municipal entity into the individuals. And the reality is, quite frankly, we are already having trouble recruiting people to come work for our city or most of the cities in the state. The more roadblocks or the more personal liability that we impose on individuals, even who are acting in good faith and not intentionally, we're not going to be able to attract those candidates. And that is one of those concerns that this bill raises. Those are the general comments that I have. Happy to answer any questions if you wish. Otherwise, I'm concluded.
Thank you very much for your testimony. Mr. Mullins, are there any questions from the committee? Senator Khan?
I just want to understand the willful intent. So you're suggesting that relative to page 2 and Roman numeral 4, that lack of clarity creates a problem
Yes.
for your employees?
Yes, it almost looks like a strict liability offense. You know, there's no intentional aspect to it. You know, oftentimes in a criminal offense, you have to act with some sort of intent. The representative that was here from the Attorney General's office can explain that more than I can. It's been many years since I practiced as a prosecutor, but you have to have some intent to do that. To cause the act, you know, some willfulness, some knowledge, some intent, something, you know, greater than, you know, sort of mere negligence, although negligence can arise sometimes, I suppose. But there's just no standard in this, so it looks like a strict liability offense.
Thanks.
Are there any further questions? Senator Gannon?
You were good on my willful and intentional, thank you. The violations, the $1,000, so if they release the information, is that going to be, if they let the same information go to 100 people, would that be 100 different $1,000?
The language says each such violation. So my interpretation of that, again, would be yes. It would be for each. In the land use context, it arises in a similar fashion. For each day that a violation continues, you may be subject to the penalty amount. It looks very similar to that language.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much, Mr. Mullins.
Thank you.
The chair will call Neil Kirk.
Good afternoon, Madam Chairman. Good afternoon to members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I'm representing myself. This bill, I think, was put in to deal with the fact that currently, under both federal and state law, government officials can find out who I've called, my telephone numbers, the websites I visited, where I am, if I have geolocation on my cell phone, and what email I've sent, among other things. Simply by asking for it, if the companies that have this information are willing to share it. But there's no prohibition or the state or local officials from getting this information. There's no prohibition on them from using it for whatever purposes they wish. In light of the constitutional amendment that we passed recently, the Informational Amendment, which says government shall not obtain intrusive information about individuals' personal information, it seems to me that the kinds of information that I just suggested to you are available today simply by request or with a subpoena from government officials is exactly the kind of thing that people by their 81% margin said we don't want to happen. That's not the government's business. And this bill tries to put that sense into effect, but balancing the need to run government and provide services and protect people the way we expect, most of us expect government to do. So while there's a general ban on government acquiring this information, there are significant exceptions. The most comprehensive one is the one that says third-party, this is paragraph Roman 3, that says any information, personal information that is necessary for an agency to fulfill its regulatory, investigative, adjudicatory, or administrative function is exempt because the legislature has already made the determination that we want those things to happen. Representative Irf assembled just about every state agency. They were all invited, most of them came, to a meeting, I believe it was last fall, to deal with this issue, and the Attorney General representative was there, and the grand jury concerns that you heard raised were not mentioned by that individual, and of course it may have occurred to some folks subsequently that this was a problem. But I put it to you that the language on Section 3, A, says state regulatory or administrative agencies, and I believe the Attorney General's office is an administrative agency, if they're doing investigations, those investigations are exempt. Now, if the grand jury's investigation is not an investigation, then certainly that was intended to be exempt, and if you need a specific language to do that, please insert it. With respect to the issue of willful and the number of violations that might occur, there was a great deal of discussion in the House about whether willful should be in or willful should be out. Eventually, they decided it should be out. From my point of view, I like the idea of willful being in because there are some people who inadvertently do things, and this bill is not designed to punish the unwary. It's really intended to put a barrier against the intentional violation. I'm not sure how to handle Senator Gannon's question about multiple violations. The idea was simply to make some sort of punishment real so that if an individual found that his information had been inappropriately obtained by the state, the individual had some sort of a remedy. And the idea wasn't that it would be multiple millions of dollars. The idea that it would be something that would make the individual whole financially if possible, but also set a precedent that there is a price to be paid for a government intrusion, an unnecessary intrusion into personal information. I'd point out that the intent of this bill is not to involve the private sector. This bill really only is designed to say what government may and may not do, which is the basic nature of the constitutional amendment. There's a specific section here, Roman 507H3, which says this chapter shall not be construed to create a cause of action against a corporation or its officers, etc., for providing information to government in accordance with the provisions of this chapter. The idea of the whole idea of the bill is to say what government can and cannot do. It's not to say what private sector can or cannot do. The private sector can either continue its practice of giving or not giving information to government. But they can't be sued if they do, and a person feels, oh my goodness, my information was inappropriately given, I'm going to sue the corporation because they have deep pockets. This says no. This is a rather small first step in implementing the constitutional amendment. The bill is introduced in the House, and prior versions of the bill were much grander. Reality came to the fore. This is a relatively narrow bill, and I hope the committee will amend it as appropriate and pass it on to the full Senate. Thank you, Madam Chairman. That concludes my testimony. I'd be pleased to answer any questions if the committee has them.
Thank you very much for your testimony, Mr. Kirk. Are there any questions of Senator Gannon?
Thank you. Thank you, Representative Kirk. I know you're really good with privacy stuff, so I'll try to learn from you. On section 4 and 5, where you talk about, it mentions any person, so that's the individual actor. You had talked earlier about you wanted to get the remedy from the state, but aren't you going to now be going after that individual person personally, as opposed to, or does that mean you're going after the remedy you wanted a remedy from the state, but you seem to be going after the individual person who might have made this innocent mistake?
It is true. This language would apply to a lawsuit against both, let's say, the AG's office or the Department of Health and Human Service if they violated it, and also against the individual state employee who was the person who did that. It's possible that you have rogue employees. Not likely in New Hampshire, but it's possible. This is designed to deal with that situation.
Okay. Thank you.
Okay, are there any further questions? Seeing none, thank you very much.
Thank you,
I'm
Madam
looking
Chairman.
back and forth between the two of them, and they're signaling each other. I'm like, they're conspiring. Okay. The chair will call David Goldstein. Good afternoon, Chief.
Good afternoon, Madam Chair, members of the committee. For the record, my name is David Goldstein. I'm the police chief for the city of Franklin. I've been a police officer for more than 42 years and a police chief for more than 18 years in 2 separate jurisdictions. I represent the New Hampshire Association of Chiefs of Police, and we ask that HB 597 be ITL'd. We believe that there are a number of unintended consequences relative to this bill. Quite frankly, we think that it would make it impossible for police to gather open source information from social media that anyone can otherwise obtain, and prohibit law enforcement from using that information. Information readily available to the public, such as social media sites, third-party contractors who obtain public information and collect it for anybody else's use, including credit reporting or even use of websites, would be limited as far as law enforcement is concerned. We believe this legislation will significantly hobble law enforcement from doing its job to protect the citizens of New Hampshire. The bill does prohibit law enforcement from gathering and using public information that we use every day to identify criminals within our society. We believe that the bill, as I said, should be ITL'd. I'm going to be brief. I'd like to just use one example, and for this example, I'm going to draw Senator French in a little bit because it deals with his constituency. And over the years, I've had to reject individuals for employment because of what I've seen on social media. And recently, I had an application for a police prosecutor, a bar-admitted attorney, and I'm sure that the lawyers in the room might identify with some of this. And quite frankly, this individual had very strong credentials, and I was leaning toward hiring this individual as a prosecutor for the Franklin Police Department to cover cases in both circuit and superior court. And when my background investigator was looking into this individual's records, one of the references said, "Have you checked this individual's TikTok page?" Now that to me represents a third party, the individual that referred us to that. So we did, and what I found was incredibly negative. And I called our city attorney and I said, "What do I do?" And he said, "You have to look at each and every entry that this individual's made on TikTok so you can make an informed decision as to whether or not you're going to offer the job." I said, "Fine," and I sat down. And here's the part that may involve the attorneys in the room, because I think it pushes the envelope of your canon of ethics. This individual went on a rant, about a 5 to 10 minute rant on TikTok, about how they really objected to the fact that people were going 80 miles an hour in the left lane on the highway when this individual wanted to go 95. My question to that is, if she or he were to bring a case into court based on speed, the defense attorney might ask an interesting question. "Counselor, you don't believe in speed limits. How can you prosecute a case that's based on speed?" So, in other words, I was able to reject that individual's application. But therein is, in a sense, is an issue that I believe involves a third-party information. We feel that the bill as written is designed to protect criminals, quite frankly, and not help us in doing our jobs every day. I'm available for questions if the committee has any.
Okay, thank you very much, Chief. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Next, we will call John Williams. Is he here?
Senator Carson, members of the Senate Judiciary Committee, thank you very much for allowing us to come here today. Yes, and thank you all for allowing us to come here today to provide you with a very brief commentary on House Bill 597. For the record, my name is John Williams, W-I-L-L-I-A-M-S, and also with me is
Janice Emery, third-year law student at UNH School of Law.
And Senator Carson, you probably recall, maybe some of your members who've been around for a while, that Representative Kirk, actually, you probably heard some prior testimony, so I'll keep it really short, came up with similar versions of this bill that were going to honor New Hampshire's very committed stance around expectations of privacy and keeping private information. I will say that Representative Erf, he engaged not just our agency at the Department of Health and Services, but he engaged around 10 state agencies to help work out language when the bill was put into interim study this past fall. So my commentary here is we appreciate the prime sponsor, the time he took to work with the various state agencies, and he addressed our concerns, making sure that there was a carve-out or an exception as it relates to our agency's services that we provide based upon our administrative and regulatory functions. That concludes my testimony before the committee today. Although we did not take a position, I did feel it was important enough to note that in the sense, like Senator Carson working with you and your committee members, you do a great job. I just want to acknowledge that Representative Erf did all due diligence around working with our agency as well as others. So thank you. So, Ms. Emery.
Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. Okay, next we're going to hear from Rick Fabrizio. Good afternoon.
Good afternoon as well. Thank you for letting me speak before you. I'm Rick Fabrizio. I'm Director of Communications and Public Policy for the Business and Industry Association, New Hampshire Statewide Chamber of Commerce and leading business advocate. BIA strongly opposes House Bill 597, and we ask that you kill this bill. The bill is built on a vague definition of personal information and has troubling language regarding constitutional statutory exemptions of privacy. Privacy bills have explicit language of what entities and individuals can do with information. HB 597 does not. This bill is especially problematic because it extends to third-party providers of information and services. Despite the assurances by several before me that it's limited to government, several of our member firms do not agree, and that includes internet service providers, financial organizations, healthcare organizations, insurance companies, law firms as well. The belief is that it would include all organizations, including all businesses, even trade associations and chambers of commerce. HB 597 doesn't clearly state what constitutes a violation resulting in injury. Thus, if someone claims a business or organization did something inconsistent with their expectation of privacy, that they could sue. Businesses and organizations tell us that they will struggle even to know how to comply with this law. HB 597 also lacks necessary exclusions of information already available to the general public, as well as data necessary for business operations, including human resource functions, business-to-business transactions. It also lacks expected exemptions for the Graham-Leach-Bliley Act and HIPAA-covered entities, as well as their affiliates and business associates. Furthermore, the bill would create redundant regulations and only add to the patchwork of state and federal laws concerning privacy that burden companies with duplicative compliance, leading to higher costs for consumers. I know there is a potential for amendments to this bill. However, we are of the belief that the bill is simply too flawed to fix, and that's why we're asking for the bill to be killed. I'll be happy to take any questions.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator Gannon.
Just a quick question. Line 22, where it's 507H3. Why isn't that clear enough? That this chapter shall not be construed to create a cause of action against a corporation or its officers. Why do you feel that doesn't exempt businesses when it's the clear language says it does?
I think it perhaps concerns the fact that businesses or organizations can sue. they may not be subject to that $1,000 per violation, which is also unclear, but that it would allow for someone to claim their expectation of privacy was violated by a third-party provider, a third-party contractor, opening the door for potential litigation.
Even though, can I follow up? Again, even though it seems clear, and I'm not saying I like the bill or don't like it, I'm just saying it does seem clear, shall not be construed to create a cause of action. I don't know how it'd get any more clear. If I was writing the bill on their side, the people who brought the bill, it seems like they were trying to cover.
It might be. The
Okay.
member firms who had expressed those concerns to us started out by pointing out, by saying that the bill itself is a good idea, but is bad legislation. Another called it just a horrible bill because of all of the different issues with it. And all of our member firms went through their own review process of the proposed legislation, including legal review, and they came to the same conclusion that it presents a risk of litigation for them.
Okay, I'm good, thank you.
Are there any further questions? Seeing none, thank you very much for your
Thank you.
testimony. Next, we're going to hear from Nate Grays.
Thank you. Nate Grace for the New Hampshire Municipal Association. We oppose this bill. I won't reiterate what Attorney Agati or what any of the other members who have already testified have stated. We certainly do echo those concerns about the grand jury. And I will just note for the record that as Attorney Agati pointed out, oftentimes it's a local police officer that is a municipal employee who is the one who is appointed by the grand jury to act to gather information. We have additional concerns besides what you've already heard from Attorney Mullins and Attorney Agati and Chief Goldstein. We are concerned that there's no definition for the terms acquire, collect, retain, or use in line 22. And since those would be the ordinary uses of those terms according to how statutory interpretation occurs pursuant to Chapter 21, it's possible that there'll be circumstances where municipalities will be given information from third-party providers of information services, which they would not lawfully be able to acquire or obtain, and therefore they could inadvertently be in violation of this statute. And as Senator Gannon has pointed out, in lines 19 and 20, as well as 17 and 18, there's no intent attached here. So it's entirely possible that you'll have a circumstance where a municipality or some employee at a municipality will be given some information that they wouldn't be allowed to have if this were to be law. An additional concern that we have is under line 20, where the person who suffers injury, which is also not defined, as a result of the violation, this chapter shall be entitled to damages from the person who committed the violation. Again, you'll have circumstances where it won't be clear who that person is. You know, in something like a police context, is it the police officer who is undertaking the investigation, which would violate the chapter? Is it the sergeant that approved that or told him to go forward? Is it the police chief? Is it the municipality as a whole? It's simply not clear, and we're very concerned and echo the statements of the prior speakers that there's a lot of vague language here. It's going to be very hard to implement, if at all possible, and we just don't think it's workable as it exists. And I'm happy to take questions.
Thank you very much for your testimony. Are there any questions from the committee?
Thank you.
Seeing none, thank you. The chair will call Andrew Kingman.
Hi, good afternoon. How are you, Madam Chair, members of the committee? My name is Andrew Kingman. I represent the State Privacy and Security Coalition of 32 companies across a number of sectors. I also work on the compliance side as part of DLA Piper's Global Privacy and Cybersecurity Practice Group. So I actually help clients, counsel clients through particular privacy laws across the states in the country here. I think we've heard that, and I think agree that this bill certainly was drafted with the best of intentions. I think our concerns are much more about the words on the page than the intent of the bill here. But the unintended consequences, I think, are very serious and deserve close scrutiny by the committee. I think there's a lot of ambiguity. I don't think it's clear at all that the bill only applies to information sharing with the government. I think, as others have said, I don't know how I would advise a client to comply with this legislation because it is so vague. The expectation of privacy is a very subjective standard. There are terms like content and usage that are undefined. And so when you combine that with a private right of action that we've seen in other states really become a cottage industry for trial attorneys to put private sector businesses under the gun, we believe it's a combination that means the bill should be inexpedient to legislate. We've seen with the private rights of action, companies turn down authentication and anti-fraud services that protect customers because they know that the litigation risk is so high. And again, this isn't, we've seen this in person. It's not hypothetical in nature. So I would also echo other folks' point that this lacks recognition of federal legislation and regimes that also regulate data. So there may be times when a federal statute does not preempt this bill, but doesn't recognize that that personal information would already be regulated by that. That's a very standard feature in nearly every privacy bill in the country here. So happy to take questions. Those are our major concerns. Happy to answer anything you've got.
Thank you very much for your testimony, Mr. Kingman. Are there any questions from the committee? Okay, seeing.
I guess I just want to, I meant to answer Senator Gannon's earlier question about the PRA and the clear language. That only applies to the sharing of information from private companies to government. And so any other way in which a company could be perceived to violate its expectation of privacy would be liable under the private right of action. So that's all I've got. Thank you very much.
Thank you very much. The chair will call Chris Gilrain. Good afternoon, Mr. Gilrain.
Thank you very much, Madam Chair, Mr. Vice Chair, members of the committee. Appreciate your time today to express TechNet's opposition to the legislation. Just want to echo a lot of the comments and our members. TechNet is an industry association representing more than 95 companies in the innovation space. It's a really broad umbrella of companies from your traditional search, marketplace, hardware, software, to autonomous vehicles, advanced energy, a whole gamut of innovative industries. And the kind of umbrella that covers them all is an interest in data privacy. So I appreciate your time here. And my members share the concerns raised by other groups that this private right of action does apply to a whole range of providers and activities that most Granite Staters would consider totally normal day-to-day operations. Any attempt at trying to comply with the vague and onerous definitions in this bill would result in a real change fundamentally in how Granite Staters experience the internet or their favorite apps or services. One thing that we haven't hit on, but I just wanted to highlight, is a question that came up from my members in terms of, okay, if we were somehow to understand how this bill worked and set up a compliance infrastructure at great cost and great potential liability for private lawsuits, do we then have to set up a separate infrastructure to serve as a contractor for the state. And the level of scrutiny and potential liability there, particularly as federal dollars are coming in to potentially upgrade and enhance the state infrastructure. I think that the state, if this bill were enacted, might struggle to find companies that would want to take on that kind of liability, and it would just erect additional hurdles to updating that infrastructure. So that's just one other wrinkle that we wanted to highlight. And again, happy to answer any questions our members want to be resources to the committee as you consider this and other similar bills.
Do any members of the committee have any questions? You're good to go. Senator French, no? Thank you very much for your testimony. And does anyone else wish to speak who didn't sign up? Come on down, Senator, Representative, go ahead.
Thank you, Mr. Chairman. A very brief comment. Chief Goldstein said that this bill would prevent the department from acquiring information that was available to the public. I think that was considered by the House. If you look at paragraph 1, an individual shall have an expectation of privacy, etc., in information given or available to third-party providers and not available to the public. Now, if that needs to be placed elsewhere in the bill, there was no intent to prevent anyone, including any state agency, from acquiring information that was already in the public domain. The purpose of the bill is to protect information that isn't in the public domain. Thank you.
Thank you, Representative. No questions? And does anyone else wish to speak on the bill? No? That's it on that one, Jenny. Thank you. Okay. No, I closed the hearing. I said that's okay, Jenny. Give me a minute. Sharon's okay. I'm gonna thank you. Okay. Who's Kurt? Kurt, Senator Walper. What? Jenny, is it D. Lorenzo who's doing the bill? Is he here?
Representative Walper, is he signed up on this one?
Yeah, he could read the bill.
Representative Walper, are you comfortable introducing the bill? Are you comfortable introducing
481?
HB 481?
The omnibus? You can read it, Harold.
There's Representative Di Lorenzo.
What?
There's Representative Di Lorenzo.
Oh, there, okay.
Here. Sorry, we're ready for you. Go ahead and take a seat.
I didn't know.
Perfect. Thank you. Perfect. I just started.
Senate Judiciary will start HB 481. Representative Di Lorenzo, am I correct? Nice to see you today.
Thank you. Good afternoon.
Good afternoon.
My name is Representative Charlotte Di Lorenzo, and I represent Newmarket and Newfields, Rockingham 17. I am a third-term rep, and I serve on the House Judiciary Committee. The bill we have before us, HB 481, is to establish the office of a right-to-know ombudsman and to make an appropriation. Now, this bill is from 2021. It's kind of been, moved around a little bit. It passed the House. It passed the House Judiciary Committee 21-0, and then it went to the House floor, where it was passed by a voice vote. From there, there were a couple of work sessions in House Finance. And so now the bill is back in this body. But I would urge the senators to vote yes on this bill. It's been a long time coming. And I think that New Hampshire desperately needs an ombudsman. So the role of the ombudsman is to be as a administrator for the ombudsman program, and they would accept and deal with complaints coming from citizens, public agencies, local and municipal government. So any person aggrieved by an act done by a public body would have recourse to going to have the issue resolved through the ombudsman. And it's an alternative to filing a complaint in Superior Court. And when we look at this program in position, the fee to have a hearing with the ombudsman is $25. The fee to go to Superior Court is in the hundreds of dollars. And so when we designed this bill, we were looking for a faster, cheaper, and more conciliatory way to resolve disputes between citizens and public bodies. So are there any questions?
You were very clear for me. Thank you. Does anyone else on the committee? Go ahead, Senator Khan.
Thank you, Mr. Chairman. In the process, so if a person has filed with the ombudsman, the way the bill is written, that person then has the ability of going, if they don't like the decision of the ombudsman, they can go to the Superior Court.
Absolutely, yes.
And unlike with other appeals, they get to hear that entire complaint again at the Superior Court. Is that
That's
right?
right,
That's
yes.
your intent.
Yes.
As opposed to challenging specifically that the ombudsman failed to recognize certain statutory requirements in that action. My point is that a precedent is set in that initial hearing with the ombudsman that is not the basis of the consideration at the Superior Court. Is that right?
Oh, I'm not sure that I understand your question.
That by having held the initial hearing with the ombudsman,
Right.
that record has no bearing on the complaint to the Superior Court.
That's correct.
And it does set up a double hearing kind of situation, which is unusual to other actions. And I guess I'd compare that to, most recently, we created the Board of Appeals for planning board decisions. And that is, can go to wherever you start. If it goes to the next body, you can only challenge it based on an error of fact or an error of the application of law or the municipality's rules. That only challengeable on the basis of an error, not on the retrying of the entire case.
Right.
And I'm surprised that we have not adopted that in this legislation.
Okay.
And I have that correct? I mean, I think I have that correct.
You're correct, yes.
Yeah. So that, okay.
Okay.
I just wanted to establish that because I think that that's a key point to, is this creating a lot more case filing and work on behalf of the municipalities, the public entity, to have to go through multiple levels of case finding.
Well, Senator, the ombudsman process is not mandatory. A person has the option to go directly to Superior Court.
And I guess I wonder, why would they do that if they have the option of having two different bodies render a decision on the same case?
I'm sorry, I'm not reading you, but that is not what would be happening. A person has a choice. I have a complaint or an issue with an agency or a municipality. I can go to the ombudsman, or I can go to Superior Court. The decisions of the ombudsman aren't. If a person chooses to go to the Superior Court after a hearing with the ombudsman, the court doesn't make the decision on the basis of the merits of the previous meeting with the ombudsman.
I understand that, and I guess, I think I have it correct, that if I start with the Superior Court, I can't go back to the ombudsman for a decision. If I start with the ombudsman, I can go to the Superior Court.
That's correct.
Which I think brings me back to the point, why wouldn't I start with the ombudsman if I have two chances of success?
You would.
I would. Yeah. Yes.
Thank you, Senator Khan. So you understand he doesn't like the second bite of the apple, right?
I'm sorry, can you hear you?
You understand where he's going, right? He doesn't want you to have a second bite at the apple and just, do you understand where he's going? He doesn't want you to have a second shot. Why not just do it in one? He doesn't understand
Oh, okay.
what are we adding by getting the ombudsman if I'm just gonna, okay, I wasn't happy with that decision, now I'll try again. That's where he's going. Okay, thank you. Thank you, Senator Khan. Thank you, ma'am, for your
Thank you.
testimony. Any other questions?
I also brought a report with me of the Maine Ombudsman's Office. It's a 2021 report.
I'll read it over.
They've been very successful. I spoke with the Maine Ombudsman yesterday and about this particular position, and she has offered to be a resource once we get that person on board. So,
Thank you very
thank
much for
you.
your testimony. We appreciate it. Thank you. Representative Walper? Good to see you again, Representative.
Thank you, Mr. Chairman.
So long.
Members of the committee, it's been so long since I've been here. Again, for the record, my name is Representative Kurt Walper. I represent Stratford District 3, the towns of Stratford and New Durham, and I would like to begin by addressing Senator Khan's question. So, the Ombudsman does not follow judicial procedure. The Ombudsman can take all kinds of evidence and make judgments. This is established the way it is, that then you can appeal that to the Superior Court, because if you do so, you then get the full judicial process. Now, along with that Ombudsman process, what the Ombudsman find, if you look at 97 AC, Appeal and Enforcement Roman 1, because I don't have a line numbered one the way you do, so. It says that the Ombudsman's ruling shall be attached to the document initiating the appeal, admitted as a full exhibit by the Superior Court, considered by the judge during deliberations, and specifically addressed in the court's written order. So the Ombudsman has done an enormous amount of groundwork and has issued a clear ruling, which now, obviously, the losing side has some kind of problem. And so they want to go to Superior Court. We expect, and that's why we left this in. So for example, if you go to the Housing Appeals Board now, which is similar to this, right? The only appeal is to the state Supreme Court. The Housing Appeals Board does not follow judicial process, just like this ombudsman does not. But the only appeal is to the state Supreme Court. That is a very expensive, very difficult procedure. The Ombudsman rulings, when not appealed, become equivalent to Superior Court orders. They become, and that's a big hope from this, is that the Ombudsman's rulings will establish a consistent body of law. But the Ombudsman is not doing judicial process, and so people should not be denied their rights to full judicial process. And that's why we left the Superior Court in there. In addition to that, the appeal to the Superior Court is a lot easier than an appeal to the state Supreme Court. And if you go to Superior Court, that in itself can be appealed to the Supreme Court of the state. Now, we're very hopeful that that will not need to occur, but that full legal remedy that you have as a citizen is still available to you, even if you choose the what we expect to be faster, cheaper, and thing going through the Ombudsman, right? So that's why it's the way it is. This was really argued out at the Right to Know Commission, and they spent quite a bit of time with constructing it this way, for the reasons that I've just explained. It's the same thing as attaching it to the Secretary of State. Right? There was a lot of resistance in the House. They wanted it attached to the Attorney General's office. The Commission decided, and we have supported right along, having it with the Secretary of State, because by attaching it to the Attorney General's office, you create, or could create, a conflict of interest within that office. Whereas the Secretary of State, we felt, would hardly ever be in such a position, and so it was better attached over there than to the Attorney General's office, and they'll talk about the fact that they can handle that pretty easily. So I guess I think that'll just conclude that. That's all. Just leave that with that. And if you have anything else, I'll try to answer any other questions you might have.
You've clarified it for myself, and I think, go ahead, Senator, if you have a question.
Thank you, Mr. Chairman. And I think, I just think you were referencing page 3, line 18.
I don't have a numbered copy. I can't answer. You have to tell me the paragraph number.
For the committee's reference, I think I have it correct. The Ombudsman's ruling shall be attached to the document initiating the appeal.
Right.
Yeah.
But it's more than just attached.
What was the vote in the House committee on this? You recall?
I think it was 18-3.
And you mentioned
might have been more, might have been. Oh, I don't know.
Well, I can look it up.
Okay.
I'll look it up. What is?
We've passed this bill out of Judiciary at least twice before. Well, very similar bills, and they've always got stuck in finance.
Okay. 16.5. Thank you. And then lastly, what was the commission that you mentioned?
The Right to Know Commission 2017. The report's available through the General Court website.
Thank you.
Thank you, Representative. Appreciate it.
Thank you.
Kevin Craig, Representative Craig.
Yes.
Come on down. Good to see you.
Thank you, Mr. Chair. Thank you, Senators. My name is Kevin Craig. I'm the representative from Coos County, District 4. That is the towns of Lancaster, Dalton, and the unincorporated place of Kilkenny. And you were asking me for my bill, correct?
What's that? Is this your bill?
Is this 570? I had not asked to speak on any
481
bill other than mine.
Yours? We're on 481.
Yes, no, I had not asked to
Oh, okay, they
speak
had
on.
you down here where you signed in, I don't know.
Oh, I signed in support, but I did not ask to speak on this one.
Oh, okay. Okay. Sorry about that.
All right.
My fault.
All right, thank you.
Thanks for coming anyways. It was good to talk to you. You look very stately.
Don't
Actually,
leave.
you could be on a portrait, really. Let's see if I can read the handwriting. Oh, I know this one. Natch Gaias? I know I should know it better than that. I apologize.
Sorry.
Sharon does the heavy lifting. I just sort of.
You'll get to see me plenty more, hopefully. Nate Grays for the New Hampshire Municipal Association. So we support this bill. We support the concept of the right to know ombudsman. We think that it could provide a faster and less expensive process for resolving right to know law complaints, and that would obviously benefit everyone involved. As far as resolving the issue of the appeal process and the two bites of the apple, that's really a policy decision for the committee. What I would say is that, as to echo part of what Representative Walper said, the appeal to the Superior Court might be a better option because it may provide a faster resolution than an appeal to the Supreme Court, as well as being less expensive. As far as amending the bill to limit the ability to relitigate portions, that's something we would be comfortable with continuing to support the bill on. And I do know that Attorney Mullins from the City of Keene is here as well to provide some additional comments and concerns he had about the bill. So I defer to him on that.
Thank you for your testimony. Any questions? You are good to go. Thank you very much.
Thank you.
Charles, I'm thinking it's Dussel? I think it says Charles Dussel. I got to get real glasses. These dollar store ones are just not cutting it. But then it would be Patricia Lovejoy. Patty, good to see you again. How you doing today?
I'm doing just fine.
Awesome.
Thank you. For the record, I'm Patricia Lovejoy. I'm the Senior Deputy Secretary of State. And I'm here representing, obviously, the Secretary of State regarding the portions of this bill that relate to the Secretary of State's office. The first being on page 1, that it would be administratively attached to the Secretary of State's office. We are fine with that. There's no issue with that. On page 4, it at the very top says that the amounts necessary for the position will be appropriated to the Department of State. There are no numbers attached on the fiscal note as to how much that would be, but obviously we are expecting that this would be a unclassified position, would need a computer, et cetera. The Secretary of State's office does have the necessary space to be able to accommodate this. I know that versions of this bill have been around for a couple of terms. In my previous life on finance in the House, part of the issue was the money attached to it was nowhere near adequate. This is not saying how much would be there, but the amount that is necessary would be there. So it would not be coming out of our current budget, but would be administratively attached to us. And we are fine with that.
Okay, thank you. Any questions? Thank you, Ms. Lovejoy.
Okay.
Have a great day. Frank Knack. How are you doing today, Mr. Knack?
Doing well. How are you doing, sir?
Could not be better. Thank you.
Mr. Chairman, members of the committee, thank you all for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire. I handed out testimony from my colleague, Gilles Bissonnette. I believe he has submitted that to y'all in advance of the hearing. Just want to focus on a couple of things, and one is just kind of at the macro level. You know, as we all know, transparency is a cornerstone of good government, and in that realm, New Hampshire is failing. Back in 2015, the Center for Public Integrity evaluated the public record laws of all 50 states and ranked New Hampshire 49 out of 50. Since that time, we received an F grade. Since that time, there have been some reforms through the courts, but not nearly enough to get New Hampshire to the place where it needs to be to ensure that we have a government that is transparent. Again, this comes out of the 2017 Study Commission. We think it's important that individuals have an easier and more cost-effective way of getting information about how their government is functioning. Just to give you all an estimate of what it costs right now, a right to know lawsuit costs $280, and then the cost of litigation. And so we think this provides individuals in our communities an appropriate and more cost-effective way to get information about how their government is functioning. So thank you, and happy to answer any questions.
Who was 50th?
Actually, should have looked that up before I came, but I did not. I apologize.
Thank you. Does anyone have any questions? Thank you for your testimony. I'm sorry, Senator Khan.
Thank you, Mr. Chairman. I probably should have asked that of the Secretary of State's office. There are about 600 cases currently. Is that what you've, I think it's documented someplace, but I'm just trying to establish for all of us at this public hearing, it's a lot of cases.
So, looking at the fiscal note in this bill, it talks about, for the last 4 years, there were 67 total right to know complaints filed. So 17 and 18, 10 in 2019, 13 in 2020, and 27 in 2021.
A lot less than what I was thinking.
According to the fiscal note, yes. That's the limit of my information, though.
I'll look at that right now. Thank you, Mr. Chairman.
Thank you. Okay, thanks very much for your
Thank you
testimony.
all.
Appreciate
Appreciate
it.
your time.
I'm going to go with Laura Orlo. I'll let you say it.
That's why I don't see that. That's why it's the first name.
I didn't write clearly.
That's why he goes with first names. He just let me in on the secret of a chair.
That's okay. I probably didn't write very well.
No.
Lori Ortolano. I live in Nashua. I'm a member of the Vice President of Right to Know New Hampshire, and our organization is strongly supporting this legislation. This bill has been well vetted, and the time has come to codify it into practical law that will benefit many. David Sad is our organization president, and he sent in written testimony citing the Center for Public Integrity in 2015 evaluated the Freedom of Information laws in all 50 states as part of a state integrity investigation. And in the category of public access to information, New Hampshire earned a grade of an F, and it ranked 49th out of 50. In the category titled In Practice, Citizens Can Resolve Appeals to Access Information Requests Within a Reasonable Time Period and Cost, New Hampshire received a score of a 0. Mr. Sad provided the reference in his entire document that was emailed as testimony. This grade speaks to what I am living and seeing in filing requests for information in Nashua. The burden and costs on citizens is simply too high. This year, there's been a significant increase in requests for assistance that have come into Right to Know New Hampshire. Last month, we usually get 5 or 6 requests. I had 14. The state is long overdue to overhaul the system and balance the burden and the cost scale. I filed a large right to know lawsuit in early 2020 involving assessing records in Nashua that was heard before the court in December of 2021 in a bench trial. It cost about $150,000 to bring this to trial. Municipalities, particularly cities, have the benefit of our deep collective taxpayer pocketbooks and can create responses that obfuscate citizens rather than assist us. Those that choose to fight back face horrendous legal bills and the loss of our reputations. I also feel that national catastrophes create opportunities for governments to behave badly, and this pandemic is no exception. The establishment of the Ombudsman Office will pull away that power play. This will give all citizens a low-cost method to have a challenge reviewed and settled by an attorney. It has the benefit of reducing response times, taxpayer costs, and pulling these cases out of the local courts. I was able to recoup about $8,000 in legal fees for sanctions against the city. This is a pittance compared to my costs. And I'm waiting for the determination on that big case, and certainly I'm going for legal fees. But the result of a case that size has now made me become a pro se litigant. And I've gone in pro se on 2 cases. I won the first case on February 7th in a ruling by the court. The second case went into court last Monday, and the city tried to settle, admitting they had committed errors. And I didn't accept the settlement. I went into court on that as well. I don't want to sue my city, and I don't want to be a pro se litigant. I just want my information with ease and minimal stress. Let's streamline the complaint process, level the playing field for citizens, and open the flow of information in New Hampshire. please support this bill.
Thank you very much. Does anyone have any questions? Nope. Thank you very much for your testimony.
Mr. Chair,
Sorry.
what city were you referring to?
Nashua.
Thank you. Marjorie Smith, I can do that one. I'm really good at that.
Mix them up and makes you look good.
Marjorie?
Representative Smith had to leave.
Okay.
Favor apologies.
Thank you. Charlotte Di Lorenzo? Okay, that's right. That was you. And we are all set. Anyone else wish to testify on 481? Come on down.
Apologize, I thought I had signed my sheet.
Yeah, it must be another sheet.
There are many of them up there. Hello again, the members of the committee. Thank you very much for hearing my testimony. Tom Mullins. I'm, again, the city attorney for the city of Keene. I think, again, to kind of talk about some of the practical implications of this proposed legislation. First of all, I'd like to say that you might want to have a little box that says maybe it depends about support or opposed, because you know it's one of those things. My review of the bill, and I've provided some specific comments in writing. I basically took the bill and went through it in a Word format and inserted comments at various sections, which I'll go through a little bit more briefly. But I have to say that the idea of having a streamlined process, as the New Hampshire Municipal Association believes, is not one that I think that municipalities would be opposed to. I think it's important for the parties to be able to do that in a more expeditious manner. I've been in front of the Superior Court on right-to-know complaints, and I understand, and especially for individuals out there in the citizenry, it can be an intimidating process, et cetera, to do that sort of thing. But on the other hand, I think that the bill needs to be balanced. I share Senator Kahn's concerns with respect to the way the de novo provision is drafted, and I'll get into that in a second. But you know, that's the very first concern I have with the statement of intent with this, which that is going to be simpler, less expensive, and faster. Based upon the terms of the bill, that's not necessarily true. What will happen, and I would do this, and I think the folks in the Right to Know New Hampshire, or people who have some familiarity with the Right to Know process, they would certainly, I would, go to the Ombudsman first. There is no particular reason not to do that. And I'm not suggesting that the Ombudsman would do something inappropriate. That individual is going to be a lawyer, going to be admitted to the bar in New Hampshire, is subject to all of the ethical rules that I am, and I have to assume that that individual will act in accordance with the law and the facts and make a decision. I think that's perfectly appropriate. The issue, as I said at that point, is what happens afterwards, which we will talk about. But a couple of things that sort of jump out at me in the bill that I point out in my comments. It's a little confusing. Under Section 2 of the bill, which is lines 5 through 21, there seems to be language that's deleted in this version of it, which is then put back in Section 5 of the bill. So it's a little unclear which one applies. And then with respect to Romans 2, 3, and 4, under Section 2, those are inserted in this version, but seem to be deleted under Section 5. So I was just a little curious about how that operates, and you might want to clarify that. I did have some concerns with respect to some of the language in the bill, as I point out in my comments. Things like information or records, you know, that needs to be consistent. Are you okay?
Sorry, no, it's just the noise.
Oh, got it? You're looking at me like, nobody's ever accused me of being too quiet, so I just wanted to make sure. But the language in the bill should be consistent. Information is a definitional subset of governmental records. It's not something that's independent of that. Records themselves, the statute doesn't define records, it defines governmental records. So I pointed out those areas where, in terms of a sort of a clarification process, it would be helpful to clarify exactly what those terms refer to. I was interested to see on line 20 of the bill the reference to citizen-initiated appeals. There's no definition of what a citizen is. As far as I know, I can't find a definition of what a citizen is in New Hampshire. So the question that arose was, citizen-initiated appeals have no filing fee. Does that mean if we have a complaint coming in from outside the state of New Hampshire, how does it apply in that kind of context? And I have to tell you, the question of whether an entity outside or an individual outside of the state of New Hampshire can proceed under our right to know law is still an open question, as far as I can tell. The New Hampshire Supreme Court has alluded to it a couple of times. The United States Supreme Court appears to think that New Hampshire has a statute in which only citizens of the state can file requests. So that's a little bit ambiguous and will need to be clarified at some point, probably not as a part of this bill, but I would suggest to those who are interested in forming a commission who follow this should actually deal with that. The more substantive issue that I have is the one that Senator Khan raised, and that is that you go to the Ombudsman makes a decision, you have an appeal de novo to the Superior Court. That means that the Superior Court, even though it takes in the information that comes to it from the Ombudsman, runs this matter all over again. As somebody who practices in this field on behalf of the city of Keene, I would much rather have to go to a place once. Or if I have to go a second time, I'm going without the burden of having to reestablish the entire case over again. Municipal resources are stretched like everybody else's, and to have a municipality engage and expend more of those resources, not necessarily outside legal expenses, but the resources within the city, that I think seems to me to be inappropriate. My suggestion with respect to that is have the action before the Ombudsman, and then if there is an appeal, have it go to the Superior Court, but have it based upon the same type of appeal that happens from a zoning board of adjustment or a planning board decision. And I have language in the comments that states to that. Basically, I'm looking at the language of RSA 677-15, which is an appeal from a planning board decision. And basically, in essence, what that statute says is that the court, on an appeal from the Ombudsman, may reverse, affirm, or modify the Ombudsman's decision if there's an error of law, or if the decision of the Ombudsman is unreasonable, as determined by the court. So that at least puts some parameters around the appeal to the Superior Court at that point. And it gives the court an opportunity to look at the matter and not waste the resources that we used on the Ombudsman, to look at what the Ombudsman did and make a decision on that basis, to either reverse, modify, affirm, or perhaps send it back to the Ombudsman for some further review. And then the appeal would be to the Supreme Court at that point. But it really is this, as I think was mentioned, maybe Senator Khan mentioned it, the second bite at the apple provision that gives me quite a bit of pause. And I think most municipalities, if they had the opportunity to come over here, and I appreciate my city council allowing me to do this, but I think other municipalities would have the same concern at this point with respect to that provision. So I am concluded and available for questions if you have any.
Thank you, Attorney Mullen. Does anyone have any questions? Senator Khan, go ahead.
Thank you, Mr. Chairman. Thank you, Mr. Mullen, for providing this detail. I hope we have extra copies we can share with the sponsors. And
I don't, but I can certainly
I think
send them.
If we get that to them, they could take a look and consider advising us on an amendment. But specifically, first off, it sounds like you are supportive of this initiative. There's an element here that you think could be more costly to the defense in a right-to-know issue, and that's what you think we might be able to fix with this hearing and our recommendation here in the Senate.
As to the first part of your question, the answer to that is yes. I think that it's within the interest of the municipalities and the citizenry to have a more streamlined or approach available to resolve these questions. The idea of the Ombudsman is something that we support. I can support. I think maybe, as I noted in the comments, my concern is that there could be a lot of work for this individual. And if I were crafting, I probably would have followed the model that would have set up a board under 541 and the provisions of RSA 541A. But that's a longer answer to your question. Yes, the idea of having a into Superior Court relief is good. It's the fact that we then have a second trial at the Superior Court for all intents and purposes, because if I'm the Ombudsman, I'm going to require all the same information from the participants as the Superior Court judge would. There's just no doubt about it.
May I continue? There's nothing that you envision that would prohibit the judge in the Superior Court from requesting additional information. If there was a section of the decision by the Ombudsman that the Superior Court judge was particularly interested in, there would be nothing prohibiting that judge from asking both parties to provide additional information on that specific topic, right?
No, not at all, because the matter is de novo in front of the Superior Court. De novo means essentially like new. So the Superior Court judge is basically holding a trial on the matter and can require any information that the court needs. Query whether or not, in this bill is unclear about that, what, if any, role the Ombudsman may have if the Superior Court wanted to make further inquiry of the Ombudsman. I think that's pretty questionable under this bill at this point. It seems to me the parties would have to do that, and if I were the Ombudsman, I'd probably say, go talk to the Superior Court, don't talk to me.
If I can follow, then, I guess my question more specifically is, if this section on page 3 in the middle, line 16 through 23, if that was amended to say that the Superior Court would take into consideration the previous findings, which it sort of does already, it could also say, and there's nothing to prohibit the Superior Court from requesting additional information on those sections of the decision that they feel are, additional information would be valuable for the court's decision.
The answer to your question is that's all true, but that doesn't satisfy at least the concern that I have, that it's a de novo review by the Superior Court. There are no parameters on it. It also doesn't answer the question, I assume, that the burden still remains with the municipality. The municipality had the burden in the first instance. Doesn't specifically answer this question in this piece of legislation. I assume that burden is the same at the Ombudsman, and I assume that that burden is still the same at the Superior Court, at least based on this language. If you have a provision in there that basically says that the court will only reverse, modify, or affirm if they're, depending upon the unreasonableness of the action or the law that the Ombudsman was presented with below, that's the provision that we would prefer.
Thank you, Attorney Mullen. You all set?
Last
one, little one, real little.
Ding.
I'll keep it short.
Yeah, well,
Brevity is the soul of it.
It's that I think that the wording that you just said might be valuable for our consideration.
It's in my comments. Right, I'm concluded. Thank you.
Finished, basically.
Okay, we'll go ahead and close it.
All set, thank you. Okay, anyone else wish to speak on 481?
I don't think it is.
No, good, hearing's closed.
Okay.
418, sorry for my slow pace.
Oh, we just finished 418.
Yeah. We finished 481, we're on 418.
Okay, all right, that's so thank you.
Sorry I didn't go faster.
No, that's okay, you're fine, don't worry about it. I knew these were gonna take a little while, so. Oh my goodness, Marge is over in the hearing.
Oh, she is like one speaker.
I'm sorry?
She is one speaker.
Oh. Yeah. Yeah, Marge Smith is over, we just left her over in the other. Yeah, she is, she's over in the hearing. Maybe we can have someone introduce the bill.
Sure.
You want to, if you want. Yeah, you can introduce it
Great.
from here. Okay, but hold on, I gotta open the public hearing. Are you all set? Okay. We're going to go ahead and open the public hearing on House Bill 418. Unfortunately, Representative Smith is in another meeting, so Senator Gannon will introduce the bill.
Thank you, Madam Chair. I'm introducing 418 relative to Supreme Court reporting. This bill makes various changes to the statute governing the Supreme Court reporter and Supreme Court reports. Thank you, Madam Chair.
Thank you, Senator. The chair will call, it looks like Lori Platt.
Thank you very much. My name is Lori Platt, and I'm the current reporter of decisions at the Supreme Court. I'm here more to answer your questions. I just would briefly say that the purpose of the bill is to allow the court to transition from publishing New Hampshire reports in bound volumes as the official version of its opinions and to move to publishing it online on its current website. The goal is to increase accessibility by the public to court opinions and hopefully to make our opinions more searchable on our website, hopefully on a model akin to your bill status search engine. I'd be happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Are there any other members of the public who would like to speak to House Bill 418? Okay, seeing none, we'll close the public hearing. Pardon? What'd you say? No, just nobody was there to speak. Okay, thank you.
How'd that one go down?
And you're ready? Okay. We're going to open the public hearing on House Bill 576 and call the prime sponsor, Representative Massimilla. Good afternoon, Representative, and welcome to the committee.
Okay.
Good afternoon, Madam Chair and esteemed members of the Senate Judiciary Committee. I am Representative Linda Massimilla, representing the towns of Littleton and Bethlehem. Today I am here to introduce House Bill 576, which came before the Criminal Justice Committee last year, where it was recommended ought to pass by an 18-2 vote, went on to the House consent calendar, then moved to the Senate, where it was later tabled because of COVID-19.
I'm sorry, could you speak into the microphone? You're very soft-spoken, it's hard for us to hear.
Okay, how's that?
I think that's better.
Okay. This year it came out of the Criminal Justice Committee with a 21-0 ought to pass recommendation, and again passed the House on consent. HB 576 would provide an exception to the current filing deadline requirement for the state's crime victims compensation law, allowing children of human trafficking or sexual abuse to file a claim at any time. The nature of sex trafficking is unique due to the common trauma bonding that occurs between the victim and the offender. Because of this bond, it is common for survivors of trafficking to not recognize their own victimization until they've received comprehensive care and services. This realization could happen any time after victimization, but not a 2-year filing requirement. This is called victimization, and obtaining enough stability to file for compensation can happen many years after exploitation ceases, and recognizes that the victims are still deserving and needing of compensation to address long-lasting physical, psychological, and emotional harm endured. House Bill 576 would also provide similar exceptions to the child victims of sexual abuse to allow them to file a claim at any time. These victims may have documents attesting to their sexual abuse victimization, but be unable to demonstrate proof or documentation of a commercial element because they were victims of familial sex trafficking. This bill would also remove the contributory fault consideration for compensation relative to children of trafficking or sexual abuse. The committing of criminal offenses is an inherent element of sex trafficking, and victims do not engage in commercial sex or unlawful labor practices but by choice, but are coerced by either fraud, deceit, or survival. As such, to suggest that human trafficking survivors may contribute to their own victimization would appear unjust, considering their circumstances. Concerns about excessive amounts of claims being generated if the 2-year deadline is removed is unwarranted, since these exceptions will only apply to victims who are able to present corroborating evidence of their victimization, such as police reports, proofs of services received, or documentation of abuse or harm. In conclusion, New Hampshire has taken giant steps in the area of human trafficking by increasing the penalties for buyers of sex with minors, by including child victims of sex trafficking under the definition of abused, and allowing the vacating of nonviolent crimes committed by minors being trafficked for sex. HB 567 now acknowledges that children of sexual abuse or trafficking have a right to access some form of compensation long after the egregious crime was perpetrated against them. I thank you for listening, and I hope you will vote to pass on House Bill 576.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Senator Cohen.
Thank you, Madam Chair. Thanks for bringing this forward. I think you've explained it well. Did the Attorney General's office have any concerns about the cost, fiscal implications of this, either on their staffing to deal with this, or the fact that the compensation fund really has a very small allocation?
I don't know about the staffing aspect of it, but the funding comes from criminal fines. It also comes from bail bonds, and it also comes from the Victim of Crimes Grant and the Victim and the Violence Against Women Act. So it has several sources, as well as the fines and criminal fees.
Continue. Did you look at that fund? Is it got a positive balance to it currently?
As far as New Hampshire's their fund, I don't know. I know that back in 2020 there were 433 applications, and of those 33 that were accepted, 33 were for child sexual assault, but there was nothing for human trafficking, for child sex trafficking.
Any
follow-up?
Did you have any breakdown of that? So that there'd be some record of what the possible expectation is for additional claims against the fund?
Oh, I'm sure there will be, yes, yes.
Yeah, but from the existing records, do we have enough information that the Attorney General's office could provide that?
I am sure they could, yes.
Yeah, we don't have anybody from the office here to testify.
No. Oh, are you Lisa Lampier? Okay, you didn't sign up that you wanted to speak. I did. Okay, yeah, she did. Okay, we're good.
Very good.
Someone will be there.
Thank you, you're bailed.
Thank you.
Okay.
Thank you.
Are there any further questions? Seeing none, thank you very much, Representative.
Good seeing you.
The chair will call Lisa Lampier.
Thank you, Madam Chair and Senators. My name is Lisa Lampier. I'm the coordinator of the Victims' Compensation Program with the New Hampshire Attorney General's Office. I'm here to answer any questions about victims' compensation.
Senator Khan.
Yes.
Thank you, Madam Chair.
I heard you had some.
If you've heard the questions, please feel free to just dive in.
Could you ask them again?
Sure. It has to do with the fund and the requests to the fund. Have you sorted those requests in any manner that you'd be able to judge what the volume of unfulfilled requests, denied requests are currently, and what would be then eligible for consideration with this change?
Sure. I can tell you that no child's claim that's presented to the commission is denied. So if there's any claim for any type of crime-related expenses to a child in New Hampshire, it's not denied. For state fiscal year 21, we had 461 victims that we assisted, and out of that, there were 90 children that were assisted. I can't provide you, I can provide you with a monetary amount that we paid out of that fiscal year, but to actually tell you how much we would pay for this proposed change, I could not provide you that information. It's hard to predict. Our cap is $40,000 per claim, and we approve, the commission approved, let me see, about, 461 claims. They deny it's less than 2% of the claims that we receive per year, and most of those are denied for a contributory conduct or information that's not complete. And contributory conduct would look like perhaps a bar fight or any illegal activity.
If you could follow.
Yes, follow up.
So only 2% of the 461 complaints were denied?
Claims, right, yes.
2% were denied?
Less than 2%.
So there's there's no fiscal note to this, and
Yes.
There is.
Yes.
This is not a fiscal note bill.
Okay, I have information that was provided.
Yeah, this is just House Bill 576. There's no FN. So if you have a fiscal note, that would be great, but it went through the House, everything without a fiscal note, so.
Okay.
Mr. Lehman?
It's penalty assessments.
So it's hard. Yeah.
No general funds.
Okay. So I think it would be, Senator, I think it would be very difficult for them to assess because you never really know what you're going to get in any given year. Plus the fact that, as Mr. Lehman said, it is self-funded. So I think those are two very good reasons why this bill does not have a fiscal note.
And my reason for asking is that is the funds and the sources that are provided, has it proven sufficient, more than sufficient, over the past several years that allowing for additional claims to be made against the fund is still self-funded?
I can tell you that in state fiscal year 21, we paid out $593,000 in crime-related expenses. And then the ending fund balance as of fiscal year 21 was $936,789.
Sounds like there's sufficient funds available.
Mm-hmm. Yes, and I would say that this bill was filed last year, and it was retained by the committee, and they worked on it. And I think if there was a question of a severe fiscal impact, they would have requested to have a fiscal note attached to the bill. If you still feel that that's appropriate, when we exec this bill, we can certainly ask Finance, Senate Finance, to take a look at it and to see if they want to weigh in on it as well. We can make that request.
If I can then follow with the office representative.
Sure.
Does the Attorney General's office believe that there is any fiscal implication for this on the staff required to investigate the additional claims that are likely with this bill?
So are you asking me if there's staffing concerns?
Yes.
No, there wouldn't be any staffing concerns.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much.
Thank you.
The chair will call Ellen Kolb.
Thank you, Madam Chairman, members of the committee. My name is Ellen Kolb, and I'm a resident of Merrimack, and I'm here to speak in favor of House Bill 576. When it was first introduced, I was an advocate with a nonprofit, and I was happy to stand in a coalition with the sponsors. I've moved on. I am no longer in that position, but I have a very strong sense that this is unfinished business that I would like to help move across the finish line. One of the people that I stood by as this was first introduced was an old friend and colleague who was a survivor of sex trafficking here in New England. It's now years later. She's grown. She will be sending you her information herself. She spoke to me this morning and was very distressed that she wasn't able to be here today. But you will receive a statement from her, and I know that in part she's going to say something you may not have heard yet. In my youth, she said, having access, if I had known there was a victim's compensation fund, it would have amazed me, because it's more than just a way for a young person to have expenses paid for. The fact that people care enough to set up such a fund makes a difference. I was 18 years old before I knew people really cared about throwaway kids like me. A few $100s may seem small, but it could make a huge difference in the life of a child victimized by traffickers. And recall, this bill will allow an application for compensation more than 2 years. This woman was trafficked as a teenager, and it was some years before she was able to come to terms and to share her story, to speak about it. If there had been a 2-year limitation, she probably wouldn't have known the fund existed, never mind possibly have access to it. And she says, adding these few phrases opens the door for young victims to recognize their value as people in this world. So I'm here as the friend of someone who has survived trafficking and who thinks this bill is a good idea. And I ask you, please give it your consideration. I think it's worth passing. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. Are there any other member of the public who would like to speak to House Bill 576? Okay, seeing none, we'll close the public hearing. Let me know when you're ready. Okay. We're going to open the public hearing on House Bill 579 and call the prime sponsor, Representative Craig.
Thank you, Madam Chair. Hello again, members of the committee. Let me reintroduce myself. I'm Kevin Craig. I'm a representative from Coos County, District 4, towns of Lancaster and Dalton, and the unincorporated place of Kilkenny. I did not prepare a written testimony for you. It's simply not necessary. This is a very short and simple bill that does not reference any other statutes. It does not make any implication about immigration law or any other policies. It simply puts an immigration checkpoint on the same level as a sobriety checkpoint when it comes to our New Hampshire officials. So if they receive notice that there's going to be an immigration checkpoint conducted within their jurisdiction, they would simply make the same public notice they would if they were going to conduct a sobriety checkpoint. So that can be done through a press release, by posting on social media, email, or fax to their local news outlets, etc. I had originally written the bill so that it would use the same methods that are required by the Attorney General's law enforcement manual for New Hampshire. We decided that was a little too complicated, and so it's greatly simplified in this version. Has bipartisan sponsorship. It passed the committee with bipartisan support, and I've had support from people who are quite hardliners on immigration and from civil libertarian groups as well. I'm happy to take any questions.
Okay, thank you very much for your testimony. Senator Gannon has a question.
Thank you for taking my questions. So
Yes.
just, so sobriety checkpoint, I understand we want to, summer night, we want the kids not to drink and drive. They know it's going to be there. There's signs out there, so it serves a great purpose. It keeps people from drinking and getting in accidents and probably saving lives. What are we saving, or what's the purpose of, I'm afraid word's going to be out not to sneak into the United States. If the Border Patrol wants to be there and they want to set up a checkpoint, and you spread the word and it gets out, aren't people going to be sneaking into my country with weapons, bombs, drugs?
They would already be in the country, sir. This is for temporary checkpoints that are set up anywhere within 100 miles of the border. So the Supreme Court has actually issued different rules for different kinds of checkpoints. Of course, there is the at the border checkpoint. There's the permanent interior checkpoint, which always stay in place. There are the temporary checkpoints that this bill addresses. And then there are roving patrols, which have a different standard for when immigration officials can stop and inquire of someone's citizenship or residency status.
So at these I've been stopped at the temporary checkpoints up north, and they just look at my license, you're a U.S., whoever's with me, and I've never had a problem. Isn't the Border Patrol doing this for a reason, to catch people breaking laws coming into our country?
I can't comment on their actual motives.
Okay.
I know that is the ostensible legal reason, but we heard testimony from not only ordinary citizens, but also a member of our own House, people who are naturalized U.S. citizens, but they are of foreign birth, and they have been detained and harassed for hours. One gentleman who lives in the area and is affected by the I-93 checkpoint that's near exit 30, he has almost lost his job on occasions, because even though he is a U.S. citizen and carries his U.S. passport with him, he was pulled aside for additional interrogations every time for up to 2 hours. And he asked that we pass this bill because then he could seek an alternate route to work.
Okay, thank you.
Are there any further questions? Senator Khan.
Thank you, Madam Chair. Same line that Senator Gannon was just asking. I don't see members of law enforcement here to testify on the bill for or against. In the House hearing, did you receive any testimony from law enforcement with their concerns, along the lines of what Senator Gannon was asking, their concerns about either having a concealed operation or a publicly announced checkpoint?
I don't recall any. I believe we had some submitted written testimony questioning the need for it, but they do not conduct these checkpoints. And so it's not a burden on them one way or the other. They would only be asked to provide public notice of it.
Yep. Okay, thanks.
Are there any further questions? Senator Gannon?
Let me just take it one more step. So we provide public notice. If I'm a nefarious character, now I know the roadblock's going to be there and I'm going to go around it, or isn't the surprise stop serving a very useful and necessary purpose for our country that we're going to possibly lose?
When you refer back to your question earlier referencing sobriety checkpoints, the same could be said about them. They're publicized and drunks could simply go around instead of staying home.
Okay, thank you.
Representative, I have a question. These checkpoints are run by the federal government, not by our local.
Correct.
Our local. So why should it be the responsibility of the local police when they find out about these checkpoints? Why should they use their resources to publicize this checkpoint? Why isn't it the responsibility of the federal government to give that notice?
We can't tell the federal government what to do. The only resources involved are de minimis at best. Posting on their own social media page, sending a press release to their local news outlets, or even posting on their town website. It's all that would be required.
Representative, I heard what you're saying. I just don't believe that it's the responsibility of the state to notice people that the federal government is going to be doing it. I think that's the responsibility of the federal government to create that kind of a notice. But when you talk about the word notice, it does have a meaning. And we are required oftentimes in municipalities to publish notice in 2 public places. That's either online or it's on a town, it could be town webpage. You've got to put the notice up in town hall. It's got to be published in a newspaper. So I think part of my difficulty with this bill is that you've got to really talk a little bit about what that notice is, if you're going to require a municipality to do that.
I believe the bill contains the exact wording, if you don't mind if I refer.
Because I have the bill here, Representative. Yes. And it says to give notice to the public of the date, time, and place of such checkpoint in the same manner required for sobriety checkpoints. But the problem is, where is that notice going to be? Is it only going to be online? Is it going to be in print?
I do not. Where is the reference to sobriety checkpoints?
The sobriety checkpoint is referenced on line 6. In the same manner required for sobriety checkpoints.
I don't believe that's the current amended version.
Okay, because I have, okay, so maybe I've got it, oh, I don't have the amended version, I have this.
I'm sorry, yes, that is why we struck that.
Okay.
And submitted this amended version. The amended version simply says the notice shall disclose, if known, the date, municipality, and geographical area.
That wasn't in here. That was not in the.
And
I have it introduced.
may include publishing this information on the government agency's website and on social media, or the use of press conference, press release, radio and television coverage, postage, and flyers. Any of those are acceptable.
Okay, thank you. I do have another question. Do you think that by making this requirement that the federal government will just say, well, we're just not going to let you know we're coming and...
That's always a possibility. As I said, we can't tell them what to do. I believe that is their policy, and I believe they probably do that with regard to concern over these being shut down by the courts if they did not provide notice.
Okay, all right, thank you. Are there any further questions? All right, seeing none, thank you very much.
Thank you for your time.
The chair will call Maggie Fogarty. I think that's correct.
Yes, thank you. Good afternoon, Madam Chair, members of the committee. My name is Maggie Fogarty. I'm with the American Friends Service Committee, and I'm here today on behalf of the New Hampshire Immigrant Rights Network. I do have written testimony, so I'll just give a few highlights and then submit copies. The New Hampshire Immigrant Rights Network is a statewide coalition of New Hampshire organizations, including attorneys, nonprofit organizations, faith communities, seeking to work within immigrant communities to promote their well-being and fair treatment. And we're speaking in support of HB 579. We're delighted that this is a bipartisan bill and grateful that it received such decisive approval in the House. We hope that you will find it ought to pass as well. We believe that, and there's evidence that immigration checkpoints in New Hampshire have been used for unlawful purposes. Both the New Hampshire and U.S. constitutions prohibit unlawful searches and seizures, which generally must be based on probable cause. There is a highly regulated exception for U.S. Customs and Border Protection with regard to border enforcement checkpoints. So they are permitted within 100 miles of the U.S. border for the sole purpose of preventing unlawful entry to the country. These immigration checkpoints cannot be used as fishing expeditions of any sort, including searching for drugs and other contraband. They should not be used as a tool to locate undocumented immigrants who are already in the United States. However, the CBP checkpoints in our state have been used as dragnets, rife with civil rights violations. Immigration checkpoints in New Hampshire are an ineffective enforcement tool, and they disproportionately interfere with U.S. citizens and non-citizens who are lawfully present in the country. The decision to conduct an immigration checkpoint must be balanced against the harm that it poses to communities. Protocols must be put in place to ensure that the checkpoints aren't used for the unlawful purposes such as drug investigations, as they apparently were in the most recent checkpoint operations described in our testimony. Indiscriminate management of checkpoints also increase the risk of racial profiling and other civil rights violations as people who are perceived to be immigrants, and that's a skin color designation, are subjected to heightened scrutiny and detention. In fact, there's no evidence that conducting checkpoints in New Hampshire will ever yield results sufficient to justify the harm that they cause. From 2017 to 2020, there were 10 immigration checkpoints in northern New England, including New Hampshire. Most of them conducted on major highways and several during high-volume holidays such as Memorial Day, Father's Day, Bike Week. And thousands of people were waylaid and forced through the checkpoints. It's questionable whether CBP even had any expectation of apprehending border crossers so far from the actual border. Of the relatively small number of people who were ultimately detained, the largest number of detentions were for lawfully present people who were arrested for state drug law violations. The number of migrants detained for alleged unlawful presence was very small, and there's no evidence that any had crossed over from the Canadian border. One story that received attention was an Indonesian grandmother named Eti Tam, who was in the country for nearly 20 years trying to regularize her status, an asylum seeker. She was visiting the Lakes region with her family, and she ended up being detained for several months at great risk to her very fragile health. So the checkpoints cause great consternation within immigrant communities, among civil rights organizations, but they also cause long delays and inconvenience for New Hampshire people. There is some evidence, too, that they have negative impacts on local businesses. So the situation of the checkpoints was so troubling that in November of 2019, members of the Northern New England congressional delegation did write to the acting commissioner of Customs and Border Protection demanding an accounting. In August of 2020, the ACLU filed a lawsuit to bring a halt to these checkpoints, asserting constitutional rights violations on behalf of 2 U.S. citizens who were detained as a result of the checkpoints. So we believe that HB 579 is an important counterbalance to unnecessary, ineffective, and potentially unlawful immigration enforcement strategies. We believe that enacting this law sends a message to Customs and Border Protection that our state takes the civil rights and liberty interests of our residents, visitors, and businesses seriously, and that questionable federal law enforcement activities are not welcome. This law would also allow police executives in our state to continue cooperating with federal law enforcement agencies, but only within the scope of their primary obligations to the people of New Hampshire and the protective limits of the U.S. and New Hampshire constitutions. So the letter I'm submitting is signed by 40 individuals and 18 organizations in the state. I'm happy to try to answer any questions you might have.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Frank Knack.
Madam Chair, members of the committee, thank you so much for the opportunity to testify. My name is Frank Knack. I'm the Policy Director with the ACLU of New Hampshire, and we are here in strong support of this bill. Senator Gannon, just to your question regarding the notice and the potential implications of providing the notice, you're absolutely correct in pointing out that part of it in the context of sobriety checkpoints is around the deterrent effect. But also, if you reference the Attorney General's guidelines for sobriety checkpoints, they also point out there's a two-part reason for the notice. It is the deterrent effect, but it's also to, quote, minimize fear and apprehension on the part of the motoring public. And so it's to ensure that when folks are traveling on the roads, that they're not coming across things that could create fear and apprehension as they're out and about in their daily lives. Also, as my colleague from the American Friends Services Committee noted, we've seen strong evidence that supports that these checkpoints are not about immigration enforcement, but about drug enforcement, which is unconstitutional. And so they've been using these as a backdoor around the Constitution. And if I could just point to one court case that we were involved in, it was State of New Hampshire versus Daniel Mccarthy. The court in that case found, quote, this court finds that while the stated purpose of the checkpoints in this matter was screening for immigration violations, the primary purpose of the action was detection and seizure of drugs. And so this is a New Hampshire District Division, Second Circuit making that determination. We also, I think it's important to point out, as was, that this is not about finding people who are coming across the border. There's really no evidence of that. And in the context of what was happening with the 7 stops up near Woodstock, they were actually bringing canines to all of those stops, which was pretty obvious what they were trying to do, which was trying to detect drugs. And in our litigation, in the case I just mentioned, the CPD officer involved testified that he has never located a concealed human in a motor vehicle in his 17 years of service. So again, this points out that this is not they're not bringing these dogs for the purposes of trying to find people. They're bringing these dogs because they're trying to get a backdoor around the Constitution, and that should be troubling to everyone. And Chairwoman, I think it's also important, your question around, actually, I'll leave it there.
Okay.
Thank you.
All right, well, thank you for your testimony. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair. Well, I am interested in sort of your thoughts about the chairwoman's concerns about, you know, if we do this, will that mean the federal government is sort of off the hook? Do you have thoughts about that?
Yes, no, I think because the federal government fails to actually do the right thing, you know, it falls to the state to do the right thing to protect our community members. And so I think it is incumbent upon the state of New Hampshire to step up where the federal government is failing and to ensure that its residents are notified that these checkpoints, which at least one court has found are a backdoor around the Constitution, are in fact happening.
Thank you. Mr. Knack, previous testimony talked about the number of stops that had happened in pretty much northern New England because we share the border with Canada. Do you know if Vermont as well as Maine has this same type of legislation?
I do not know the answer to that question, but I could definitely find that out and get back to you.
Please, that would be.
Absolutely.
I think that would be interesting. So, okay. Are there any further questions for the committee? Seeing none, thank you very much for your testimony, Mr. Knack.
If I could just, I'm sorry, point out one additional thing though with your question around Maine, Vermont. And that's, if you read the order in the case I mentioned, they do note that our privacy protections are stronger in New Hampshire than either Maine or Vermont, and that was part of their analysis. But I'll get back on the specific questions too.
Thank you very much.
Thank you.
Are there any other members of the public who would like to speak to House Bill 579? Okay, seeing none, we'll close the public hearing. Oh, yeah, well, you gotta get up and step up a little bit. We have one more and then we have to accept one bill.
Oh, yes, we do.
Yes, one bill. Thank you. No, we have the, oh yeah, the police conduct thing. Yeah, because we have to get that out today, so.
We're back on board.
Okay, yeah, that's the only thing we have to do today. And I don't think the representative is here to introduce the bill. No. No, she's not here, I don't know. Maybe I'll have Senator French just introduce the bill. Okay. Ooh. It's been a long afternoon and we've been on vacation for a week and the quips are flying. Okay. Okay, are you all set? Okay. We're going to go ahead and open the public hearing on House Bill 228. Representative DeSimone is not available, so Senator French has graciously volunteered to introduce the bill to the committee.
Thank you, Madam Chair. For the record, my name is Harold French, Senator from District 7. I'm here to introduce today House Bill 228, relative to the calculation of child support in cases with equal or approximately equal parenting time. I've spent many hours reading over this, and if you have any questions, it means you haven't done your homework. Thank you.
Thank you very much, Senator. I don't think anyone wants to ask you any questions. Okay, next we are going to call Honey Hastings.
Madam Chair, Senators, I retired in 2016 after 34 years of practicing family law. I continue to do mediation of divorce and parenting cases. I present this testimony on behalf of the Child Support Working Group. The names are listed at the bottom of my cream-colored memo. We oppose this bill because it does not solve the problem in a way that is fair to children. The problem is how to set child support in cases where the parents have equal or approximately equal parenting schedules. There's 3 bills in this legislative session. You've heard and recommended ought to pass, and the Senate passed. Senate Bill 431, sponsored by your chair. There's another one that's still in the House. Given the hour and the many bills you have heard today, I will limit my remarks, answer your questions, and refer you to my memo for more on our objections. If you could look at the blue handout, which is an example of a child support worksheet, I'm going to refer to that. I'm also looking here at the bill, and there's some technical problems I see. For instance, on line 4, it says This bill would apply when there's a disparity of income, and then there'd be a rebuttable presumption of using what we call net the difference. But that leaves out the cases where the incomes are identical, and I don't know why there's that distinction. The bill goes on to say in lines 10 through 14 how to do this. And I'll show you if you look at the blue handout, which is taken about the X family, and I've described them more in my written materials. This family and also the one on the purple sheet, the Y family, were also the same family scenarios we had as numbers 3 and 4 on our presentation on Senate Bill 431. So this is done up, this is what how child support is calculated, and it's also how net the difference can be calculated. This is one child. We're assuming that there is an equal or approximately equal parenting schedule. The higher income person earns $80,000. The lower income person earns $40,000 a year. You see it listed as monthly. These calculations are done on a monthly basis. If you get down to line 7A, this is the so-called guidelines amount, in this case 1617. And then if you look on line 10, this is the proportional share of income. That is, they look at the combined incomes of the two parties, and we see in this that the obligor, the person in the obligor column, earns 68% of the total income. Then on line 11, the guidelines calculates how much each parent should be providing in terms of support. That's a key, those are two key numbers for doing net the difference. And you'll see I have handwritten in NTD, net the difference. The net the difference is subtract, as it describes in here, line 10 through 14. The amount of child support payment shall be calculated according to the guidelines if the higher income party were to pay the lower income party, and calculated as if the lower income party was to pay the higher income party. The difference between the amounts shall be the presumptive child support obligation paid to the party with a lower income. And so these are the two numbers, the 1,099 and the 517. Those are each parent's obligation, that the difference is 582. This bill would have in every case, except if they, of an equal schedule, this would be the presumptive child support number, except if they had equal incomes, because it doesn't apply there. To make it clear, I typed something up and pasted it on the worksheet, and you'll see it in the bottom right corner. So with net the difference, this is to look at what the gross incomes would be monthly. If you use net the difference, parent A, after subtracting net the difference, would have a gross income of 6,501. This is on the net the difference method. This is this 228 method. Parent B, after receiving the net the difference, would have 3,916. That would be the gross income results. If you look just above there, I put what the guidelines would be. If you have parent A minus the guidelines, then he or she would have 5,983, and parent B plus the guidelines would have 4,433. So besides the problem I mentioned of not dealing with the equal, a key thing for you to look at is which allocation of gross expenses is fair to children. The result with that the difference, the result with the guidelines. Remember, our bill, Senator Carson's bill, but I feel attached to it too, and are honored to have Senator Carson be the sponsor. Senate Bill 431 uses net the difference. In many cases, it says, however, if one parent's percentage number, that number on line 10, is 60% or more, you don't use net the difference, you use guidelines. So this is an example. This is one of the examples we used in our presentation on 431 to show what happens when there is too great a difference. So I think that this is an example, and you can look at the purple form on your own time. The family situation is described in my memo, and it's another example with even greater discrepancy in the incomes. In recommending Senator Carson's Senate Bill 431 as ought to pass, this committee showed that its support for putting kids first. The committee voted for Senate Bill 431 to ensure that children are adequately supported. When income differences are substantial, Senate Bill 431 and this committee says that fairness using the guidelines rather than net the difference. If you agree with this conclusion, which you already agreed to earlier, you would vote in expedient to legislate on this bill.
Thank you very much for your testimony, Ms. Hastings. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Marilyn Mahoney.
Thank you very much, because I think Attorney Hastings, well, former Attorney Hastings, covered everything this morning. It's late.
I thought if you were an attorney, you're always an attorney. It doesn't matter if you're working or not.
Okay, thank you.
There you go. So you're all set? Okay, thank you. We have Attorney Susan Brisson and Lisa Dukowski, if you would like to come up. We can come up together. Just make sure that you identify yourself so we can make sure that everything is recorded accurately. Good afternoon, ladies.
Good afternoon.
Good afternoon. I'm Susan Brisson. I'm the Chief Legal Counsel for the Bureau of Child Support.
Good afternoon, Madam Chair and members of the Senate Committee. My name is Lisa Dekatowski, and I will spell that for you, Dekutowski. I'm the Bureau Chief with the Bureau for Child Support Services, Department of Health and Human Services. And thank you for giving us the opportunity to speak with you today about House Bill 228. The Department of Health and Human Services, through the Bureau of Child Support Services, administers the state's child support program. As established in the Title Roman numeral 4, Section D of the Social Security Act. The Bureau has an interest in making sure that the legislature is up to date on the current status of the required 4-year child support guidelines review, and that the legislature has the sufficient information to ensure the application of the child support guidelines, and that it continues to be reviewed, adjusted if necessary, and remain in the best interest of the children and the families that we serve here in New Hampshire. The Department of Health and Human Services is required to review the New Hampshire child support guidelines at least every 4 years. The purpose of the review is to provide information and data to the legislature for consideration of the child support guidelines. And the review considers the current economic data on the cost of raising children and includes an analysis of case data on the application of and the deviations from the current child support guidelines. So the Bureau is currently in a review year, and we have contracted with a vendor to perform New Hampshire's quadrennial review, and a new child support guidelines review report and its findings and recommendations are anticipated to be received by the end of this calendar year on December 31st of 2022. And we believe, the Bureau believes, that this updated review report will yield many helpful recommendations about New Hampshire's child support guidelines for consideration by this committee. Therefore, the Bureau would like the committee to consider holding on this bill until the completion of this year's quadrennial review for more updated and current information. Additionally, the Bureau wishes to just discuss House Bill 228's potential to be applied retroactively to orders currently in force. The child support orders subject to review and modification in the manner that House Bill 228 is currently drafted does not address whether the proposed changes to the child support guidelines would constitute a substantial change in circumstances for orders that are currently in effect, and it does not state that changes would be applied prospectively.
So without clarifying that it be applied as prospective only, it could cause a burden on the Bureau's resources, and it could increase our caseload if orders that are already in effect and not eligible for the 3-year review are suddenly eligible for review under a substantial change in circumstances from the way in which it is currently written. And we certainly, as the Bureau, would be willing and able to work with the committee to assist in the drafting of any language that may help to alleviate any of those concerns. That concludes the information that I'd like to share today, and thank you very much for giving us the time to be here. Happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Senator Khan.
Thank you, thank you, Madam Chair. And thank you, I think we got your testimony in advance, so thank you for providing that. So we've got 3 bills in the legislature this session, and I'm curious, is this the same testimony that you would provide to all 3, or is there one among the 3 that you think is a better bill than the others?
The Bureau really doesn't take, is taking a neutral position on all of the bills before the legislature. We really just want to be able to provide you with the information and the knowledge of knowing that we have a current quadrennial review in place, and it may in fact provide some more current and updated data that you can utilize before the committee is for consideration in any amendments before you today and in the future.
May I follow?
Yes.
Is there a body, a commission that, in addition to your department, that would review that data besides the University of New Hampshire independently, so that the person like Ms. Hastings that has continuously provided us with testimony and application of different guidelines, that people qualified working in the field could review that and subsequently provide that information and guidance to the Senate and this Judiciary Committee?
Yes, Senator Khan. The current statute requires that the department provide a copy of the current quadrennial review findings and its recommendations by our contracted vendor who is specialized in this exact type of review to the legislature and to the governor, and it is also published as well, so that will be available.
But no specific advisory group that, that's what it sounds like, and I think that's fine. Thank you for the clarification.
Sure.
I was just going to say, I've been through this before. They do come in and they do a presentation to the committee, but usually what ends up happening is the Child Support Working Group also gets that same information, and they will come forward with suggestions for legislation.
The Child Support Working Group is not an officially convened commission.
No, it is not. It is a group of folks like Ms. Attorney Hastings who have been very, very involved in this issue. As you can imagine, this is extremely complicated, and they actually delve into the weeds, and they come out and they make recommendations for legislation.
Thank you.
You're welcome. Are there any further questions for Attorney Brisson and Ms. Dukowski? Seeing none, thank you very much.
Thank you.
Are there any other members of the public who would like to speak on House Bill 228? Okay, seeing none, I will close the public hearing. That is all of the public hearings today, but we do have a bill to exec, and I don't know how you folks feel about executing maybe 1 or 2 of the bills that we heard today. So can I get a motion to go into executive session? A move by Senator Khan, seconded by Senator French. Senator French, I always recognize you. The bill that we have is Senate Bill 456. We heard this bill just prior to the vacation. Everyone should have gotten an amendment, and the amendment deals with the suggestion that was made by our own Senator Khan, dealing with a definition of what an administrative suspension actually is. So that's what we have. Yeah, everyone should have a copy of it, because I believe it went out, I want to say, last week? Yeah, okay, good. Okay. So, is there a motion on Amendment 0926S? Okay, we can do that first. Okay, is there a second?
Second.
Seconded by Senator Khan. Okay, so we have Amendment 0926S. Is there a motion on the amendment?
I would move Amendment 926 as ought to pass.
And seconded by Senator Whitley. Is there any further discussion on the amendment? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, so we have, is there a motion on the bill as amended?
I move ought to pass on Senate Bill 456 as amended.
Okay, is there a second?
A second?
Seconded by Senator Whitley. Is there any further discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for the consent? Okay, Senator French moves consent. Is there a second? Senator Gannon moves seconds. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Nope. And I'll do this one, Jenny. Okay. I think there might be a couple that we heard today. I think House Bill 418, dealing with the court reporter, I think is pretty self-explanatory. They just want to be able to put stuff online. I don't see that as being an issue. And it is a request of the judicial branch. So is there a motion on House Bill 418?
I move on to pass.
Senator Whitley moves on to pass. Is there a second?
I'll second that. Thank you.
Okay, Senator French second. Is there any discussion on the ought to pass motion on House Bill 418? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Okay, Senator French moves consent. Is there a second?
Second.
Seconded by Senator Khan. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Senator Whitley, would you like to
Sure.
do this one? Okay. And maybe, I don't know how you folks feel about the last one we just heard, House Bill 228.
I would move it expedient to legislate.
Okay.
Second.
Senator Khan moves ITL, seconded by Senator Whitley.
Discussion,
Yes, discussion.
can we make an interim study?
Why?
Why not?
Just a softer landing? Okay.
I'll accept that.
Okay, so Senator Khan will withdraw his ITL, will you?
That's fine.
Okay. So, Senator Khan, is there an alternative motion?
I would move interim study on House Bill 228.
Okay, is there a second? Senator French, there you go. Okay, so we have a motion of interim study. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Senator French moves consent. Is there a second?
Second.
Seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Senator French?
I would love to take that up.
I know you would. Okay. Is there, I think the other ones, need some work.
579.
576?
Yeah, 597, 481. Do you feel comfortable, Senator Khan, discussing House Bill 576 about the Victims' Compensation Fund?
Well, you asked for some additional information.
Yes. No,
Because
no.
they said that they had a fiscal note, and we didn't have
No.
that?
Yeah. No, I think they might have done a fiscal analysis, but what we can do, if we want to do this bill, we can request that Senator Daniels take a look at it, and if they feel it's appropriate, they can send it to finance.
I'm not sure that it is necessary. She said that there's plenty of money in the fund,
Yeah.
there's no
Right.
staffing issues, so I don't think it
No,
needs
I
to go
don't
to
think there's
finance.
anything, I agree with you.
Okay.
Okay.
But if she's providing the information,
I thought the information would be helpful for you, because you had most of the questions.
I did.
I sit on this, you know.
You were present for that one. But she addressed the questions, no doubt, but she also indicated that there's an internal analysis of the implications of the bill that we haven't seen. So why not
Okay.
continue
We can-
to ask for that, Jenny,
we
if
can
you
hold on
follow
for-
up with her? I don't have a problem with the bill.
Yeah, we can hold on to it, and so that way we can see it, and I just didn't know how you folks felt about it, because it's not controversial. Do you have?
Sorry, no, I'm looking at my notes really quickly here for questions that we specifically gave to Ms. Lampier, and I don't see anything that we specifically requested from her.
Yeah,
If there's anything you'd like me to request and reach out to her, I'm certainly happy to do that.
If you feel comfortable, Senator, and you want that information, I mean, that's not an issue.
Yeah, I
We
think-
are way ahead of schedule.
Yeah, I know.
So we can hold
and
off on this one for a
Good,
week or so.
let's hold off and
Okay.
Listen to more questions
Be nice.
I don't need more questions, I need more answers.
Okay.
Oh, there we go.
So, so you know, when I left, I went over to the presentation that was being given by the Supreme Court Justice Marconi concerning the commission that the governor put together on domestic violence, that changes that we might need to make, both at the court level and at the legislative level. So this is a packet of the documents, so I made sure to pick one up for all of you.
Thank you.
So please make sure to take a look at them.
Yikes.
If you have questions about anything, please refer to Justice Marconi. I think this is going to be an issue that we are going to be looking with, and it's in regards to the woman that was shot by a domestic partner, and then he committed suicide. So we should take a look at the system and look at what we might need to do to improve the system to help prevent these types of things from happening. So I just wanted you all to know, and for everyone to get a copy of that
Thank you.
report
Thank you.
for your records.
Madam Chair,
Senator
before
Cortez.
we adjourn from executive session, is there objection to 579?
What do you mean, what is 579? Is that,
Senator Gannon had a few questions on it. Huh?
what's 5?
Oh, really?
Are you talking about 597?
No, 579.
Oh, okay. Okay, all right.
We
Okay.
did request more information on
Yeah, we did. I
579
asked
regarding
from the
Vermont.
ACLU.
Because of, yes, that's right, the other states. Okay, good enough.
Because
Right. The other
you know, it
states.
would be curious to see
Yeah.
what, if the other states are doing this as well.
Good.
So, okay, is there a motion to come out of
ITL.
executive session?
So moved.
Okay, moved by Senator French, seconded by Senator Khan.
Yes, indeed.
Okay. All in favor say aye.
Aye.
Any opposed? Okay, everybody. Thank you very much. We really appreciate all your work today. And we are done with